I know it's a little bit late and everybody's running a little bit behind, but we'll go ahead and get going with the hearing on Senate Bill 174, and we'll ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 174 increases criminal penalties for the crime of interference with law enforcement when that violation involves fleeing from a law enforcement officer. The bill amends KSA 215904. That's the statute covering interference with law enforcement. The current crime is either falsely reporting certain information to law enforcement, concealing, destroying, or materially altering evidence with the intent to prevent or hinder the apprehension or prosecution of a person, or knowingly obstructing, resisting, or opposing any person authorized by law to serve process in the service or execution, or in the attempt to serve or execute any writ, warrant, process, or order of the court, or in discharge of their official duties. New subsection A4 provides that the crime includes knowingly fleeing from a law enforcement officer who has reason to stop the person under KSA 222402, other than fleeing by operation of a motor vehicle. If you look at KSA 222402, it provides that without making an arrest, a law enforcement officer may stop any person in a public place whom that officer reasonably suspects is committing, has committed, or is about to commit a crime, and may demand the name, address of that suspect and an explanation of the suspect's actions. Right now, fleeing or attempting to elude a police officer in a motor vehicle is a separate offense, and that's over in the motor vehicle chapter in KSA 81568. New subsection B6 provides that a violation of that new subsection A4 version of the crime is a Class A non-person misdemeanor in the case of a misdemeanor or resulting from any authorized disposition for a misdemeanor or a civil case. It would be a severity level 7 non-person felony in the case of a felony or resulting from parole or any authorized disposition for a felony, and then a severity level 5 non-person felony if the offender discharged or used a firearm while they were fleeing. I would note that the bill as introduced would have provided for that severity level 5 version if the offender possessed a firearm, but the Senate Committee on Judiciary made it discharged or used that firearm. And I can take any questions.
All right, thank you, Natalie. Can you tell us so this passed the Senate. Do you know what that vote total was by chance?
I do not, but I can grab it for you when I sit down.
No problem. I can look it up as well. All right, committee questions for Natalie. Representative Titus.
Thank you, Mr. Chairman. What's the case law around used? So if I show someone the gun in a holster, or if I reference that I have a gun, does that elevate to used, or is it still on the person but not used?
Mr. Chairman, Representative Titus, there is some case law around that. I don't know it off the top of my head. They had that discussion in the Senate Judiciary Committee, and research pulled together some of that case law for them. And so between Jillian and I, we can coordinate and get that information sent to the committee.
Thank you. Additional questions, committee? Representative Mon.
So Natalie, the crime of flee and elude, that's just a traffic matter? And
the one over in Chapter 8 that we all think of, yes, that's in a motor vehicle.
So this just basically creates a kind of a similar thing for running away on foot, or, okay, perfect, thank you.
Further questions? All right, seeing none, thank you, Natalie. We'll now hear from our proponent testimony, Ed Klump, with the law enforcement agencies.
Thank you, Mr. Chairman, committee members. I'm Ed Klump, and I'm here today representing the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. We requested this bill. This has been a concern among our association members for over a year or so, how to address this. And it came up because the levels of interference, the violations for interference, are based on what that person is wanted for at the time of the interference. There's no distinguishing between the type of interference. And to give you an example, Kansas has a resisting arrest law, but the resisting arrest law is just a law that says there's no authority of a person to resist an arrest, and there is no sanction in that law. So what we charge a person for who resists arrest is interference. It's also the same thing we charge a person for that refuses to show us a driver's license or identification or other ways that they interfere with our investigation. They lie to us. There's various levels of that, but it's all the same penalties based on what the crime is we're investigating, nothing to enhance it for more serious violations by the acts that are concerned. And so that's what brought us here. So in 2019, 12 law enforcement officers across the U.S. were feloniously killed during foot pursuits, and another one was died accidentally during a foot pursuit. In addition to those killed, there's an unknown number that were injured in foot pursuits, some seriously. We know that number is large. This was up from 4 officers feloniously killed and 1 accidental in 2018. 2020 and 21 data was collected by the federal government in a different way, and we're not able to isolate the foot pursuits out of that. But looking at the other numbers, it appears that 2019 number is holding pretty steady. And of course, 2022 data isn't available in any form yet. So those that are fleeing on foot are the offenders this bill is designed to address. And these are inherently dangerous for law enforcement from many ways. What happens a lot of the time when we're pursuing people on foot, and oftentimes it's more than one person, they like to go and hide and then kind of ambush the officers when they go by and don't see them. And so that's one of the inherent risks, especially at nighttime when a lot of these occur. You're running through backyards, and I can tell you experiences about getting clotheslined with a clothesline. You remember, who in here remembers what those are? And experiences like that. So we have a lot of injuries. They're just inherently dangerous. So in current law, like I say, the only action that determines the severity is what the person is wanted for. So these are high-risk situations, and we believe the penalty for this type of activity warrants a higher penalty because of the risk that's imposed. A lot of our criminal laws, we look at what is the risk imposed to public safety. And this not only creates a hazard to the officers, but also a hazard to the public. Many of these cases end up in a person either forcibly entering or going into an unlocked home and ending up in situations that way. Sometimes with the residents being held. We frequently have carjackings in the larger cities with these foot pursuits. And so we're trying to address that issue too. So the revisor explained what the bill does. I don't think what might have got hit heavy enough is in order for this violation enhancement or the sentence enhancement for this violation to kick in, we put a provision in there that the officer has to have the right to stop and detain that person as a suspect as provided in KSA 22-2402. And just to remind you, that law says that we may detain a person for further investigation if we have reason to believe they have committed or about to commit a crime. And so this isn't a matter of somebody sees the police car and just takes off running. That's by case law isn't even a violation. Sure, it raises your suspicions, but that doesn't rise to the level of meeting the requirements of 22-2402. And we wanted to put that in just because we didn't want we wanted the scope to be narrow. So if we have a right to detain this person to investigate their suspicious activity that leads us to believe they're about to commit a crime or are committing a crime, then if they run from us when we attempt to make that stop, then that's when this would kick in. So we specifically also exempted out the motor vehicle fleeing because that has its own statute. And I think you're going to see some testimony that that penalty is less than what this penalty is, and that's probably true. And sure, that's one we'd like to increase to, but we've been down that path before and actually did get a minor increase in it probably about, 10 years ago or so. But those pursuits are not the subject of this bill. And so we didn't want to have two laws that address the same activity. And so we specifically exempted that out. And that's why we did that. So what we're asking for is that fleeing on foot is a severity level 7 felony when the crime is a felony that we're investigating. It's currently a 9, and that's when they're not armed with a firearm. And then severity level 5, if they are fleeing and they now, the way the bill is worded, used or discharged the firearm. And obviously that rises the danger to us and the public and everybody substantially when that happens. We're not proposing any change for this act when we're investigating a misdemeanor. It's already a Class A misdemeanor. We felt like that was maybe too far of a leap to make it a felony. And sometimes the punishment's more fitting in the Class A anyway, because the local judge has more options on jail time than you do when you get into a low-level felony because of the presumptive probation on the grids and stuff. And so that's what the bill does. That's why we're doing it. This is one of our priority bills for this year, and that's because of the safety factor and the consistency with this. I can tell you, when I was an officer, if we had 2 foot pursuits on our shift a week, it was a busy week. Today, if we have less than 4 on a shift, we probably had a quiet night. It's just become almost a standard thing anymore. And part of that is because so many times this penalty gets blended in with the other violations that we're pursuing them for. And so, you know, it's the same with the automobile pursuits. You know, there is no real penalty because it just gets melded in with everything else, and so there's no added time for that. But we believe these enhancements will make a difference, and we would ask for your support on it, and I'll stand for questions.
All right, thank you. Questions for Ed Klump Committee? Oh, there you go.
Okay,
Seeing none.
thank
Thank you. Committee, I don't see any neutral testimony, and you have a written opponent testimony from Laura Stratton, Board of Indigent Defense Services Legislative Committee. Is there anybody else here that wishes to speak on this bill? No. Senator Haley. Welcome to the committee.
Thank you, Mr. Chair. First, let me apologize, Chair Owen and Vice Chair Smith, Ranking Heiberger, for not getting my testimony on this bill in on time. I will be brief, making only verbal opposition, and we'll follow that up with the chair's permission with a written statement later.
Sure.
Again, I'll be brief. Serving on the Senate Judiciary Committee, we heard this bill. It was amended just a little bit. It's been well explained by Chief Klump in terms of what the merits might be. There are 2 quick issues in my opposition. First and foremost, to this, there will be a greater bed space impact than just one. I have the honor of serving on the Kansas Sentencing Commission, and normally they're accurate in their assessments, as does Chief Klump. He just testified that there will be sometimes 4 times a shift, that there are fleeing and eluding cases, and how that ripple effect, should this bill become law, and there being only 1 additional bed space, as suggested by the Sentencing Commission, to me, seems a bit imbalanced. I am concerned because our bed space is at a premium, and what we want to do is to ensure, at least in my case, that we have the seriously hardened or the seriously problemed threats to society incarcerated for the extended period of time, which leads to my second concern. Mr. Chair and members, there are some people who have been deemed suspicious, and the statute that Chief Klump shared with us is large enough of a loophole to drive literally a Mack truck through. The suspicion of a crime, and if someone has, well, certainly if they've committed it, but the suspicion for someone who might very well be standing on a corner, minding their own business, or otherwise posing no threat whatsoever, and then is approached and questioned as to why they're where they are and what are they doing, has happened time and time again. And believe it or not, I know it's hard to believe, there are many people in our society who are simply averse to being questioned in a hostile manner by someone when they're standing in their own regard without having committed a crime. And there's some people really, believe it or not, Mr. Chair, who are actually afraid of the police. I know. Some people say you're kidding. No, they really, and to break out running, which is what this bill is talking about, enhancing the crime, making the crime for, which will lead to a felony, is a concern of mine. It's a concern of mine because not just in Kansas, but in this country, people who have eluded or attempted to elude or to flee from the police have sometimes ended up in precarious situations, indeed injured, and in some cases beaten, in some cases died. I mentioned Memphis this year where this same scenario did occur. Now, will this have, if this bill is passed, will this have the effect of keeping people who are afraid of the police or who have not committed a crime but just don't like being questioned by authority figures in their own right? Will this keep them from eluding or fleeing? Will that have the preventative effect? And I suggest to you very strongly it will not. This bill, if passed, will only clog our bed space, our necessary bed space more so. I do appreciate that Chief Klump, in closing, did bring this before us and that we had this consideration. I would ask that you consider very carefully the true implications if this were passed, Mr. Chair and members. I do appreciate that we were able in the Senate during its initial review to change. Initially, they had if someone possessed a weapon, legally or illegally. And as you know, our Attorney General wants to change holding a concealed carry to not even have to pay any registration fee. We were able, so many people will arm themselves legally in our state. And if in fact they're approached with a legal weapon, we were able to change it that if that weapon is discharged or fired, then indeed there would be, I think, the correct application of the law. But other than that, this bill, I think, needs some genuine consideration by members of the committee prior to its being worked and passed. And I thank you again for the consideration of your time.
Absolutely. Thank you, Senator Haley. Committee questions for the senator? Seeing none. Thank you, sir. If you'll just email over your written comments when you have a chance, we'll have Colette disseminate that to the committee.
Appreciate your indulgence.
Thank you. Any further conferees as it relates to Senate Bill 174? All right, seeing none. Oh, yeah, Representative Mon.
I know it may be out of order, but I do have a question for Chief Klump.
Okay. Ed, do you mind answering a question?
So Chief, I'm trying to figure out what how this would work in practice. You have somebody standing, I'm standing on a corner. I match a description of somebody who's involved in a felony, and law enforcement comes up to me and says, as I walk across the street, says, "Hey, stop! I want to talk to you." And maybe I'm in a surly mood, and I say, "I've got nothing to say to you," and I keep walking. Am I now? You're investigating a felony. I'm not complying with the request, and I'm moving away. Am I fleeing?
Well, that's not our intent. Our intent is those that actually
Sure.
take off running and we have to chase them down. Just the passive resistance of not stopping, I mean, you know, we're going to deal with that, and that would probably remain at the lower level. I don't see us trying to charge that the other way, and I don't think the prosecutors would go that far with it.
And I understand that that's not the intent, and most prosecutors and most
Good question.
good law enforcement officers are going to deal with it other ways, but I have seen that type of scenario escalate into a weird situation, and I just didn't know. I just wanted to get your kind of input on that type of scenario.
Appreciate that.
All right, thank you, sir.
Yep. Any additional questions, committee? All right, thank you, Ed. And thank you, committee. We'll go ahead and close the hearing on Senate Bill 174. And we will now move on to Senate Bill 228, and we'll ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 228 modernizes statutes related to county jails. It also removes the requirement that every county shall have a jail. It modifies procedures used when district courts commit prisoners to jail in another county and when counties contract with city jails to keep prisoners, and it requires a medical examination before certain United States prisoners or city prisoners are taken into custody of a county jail. Section 1 creates a new section of law, and this section was actually added by the Senate Committee of the Whole in a floor amendment. It provides that whenever a person is in the custody of a sheriff and confined in county jail awaiting examination, evaluation, or treatment, the county that maintains that jail shall be reimbursed by the Secretary for Aging and Disability Services for the cost of that custody at a rate of $100 per day. The county shall be compensated for each day. If the person is awaiting examination or evaluation, then from the date of that request until the person is either taken from confinement for that examination or evaluation, or the examination or evaluation is complete if it happens there, or if a person is waiting in treatment, then they'll be reimbursed from the date of return to confinement from the completion of that examination and evaluation to the time when they go to treatment or when treatment is complete. On and after July 1st, 2022, if a county has a claim for reimbursement, then the county shall notify and provide documentation to the Secretary. The Secretary shall then certify that amount to the Director of Accounts and Reports, and they will transfer that amount from the State General Fund to the County Competency Expense Fund, which is created in subsection E of this section. The Secretary would be required to develop and implement a procedure to provide payments to those counties on a quarterly basis for those claims. And if there's no money available in the County Competency Expense Fund, then the county would be able to file a claim against the state and use that procedure. Section 2 amends KSA 19-1901. That requires every county to have a jail at the county seat. This bill removes that requirement and provides that every county shall have jail services at the expense of the county. Section 3 amends KSA 19-1903, which requires the sheriff of the county or a deputy to keep that jail. The bill retains that requirement. Current law there also requires the sheriff to keep separate rooms for the sexes, except where they are lawfully married, and to supply proper bread, meat, drink, and fuel for the prisoners. This bill retains the requirement for the separate room for the sexes, but it eliminates that marriage exception, and then it modernizes the language around providing food and medical care. The Senate Committee on Judiciary did amend this portion. It took out the provision related to the sexes and replaced it with each sex, female and male, and it also added a subsection to provide that sex means the biological state of being female or male based on the individual's organs, chromosomes, and hormone profiles. Sections 4 and 5 amend KSA 19-1904 and 5, which require the sheriff to keep a true and exact calendar of the prisoners committed to the county jail and report certain information to the courts. The bill modernizes the language there to reflect release or escape from the jail, and it also allows the sheriff to provide the district court and the sheriff's county with a physical or electronic copy of that calendar, or to access the electronic record of that calendar through electronic means. Section 6 amends KSA 19-1910, which provides that when a prisoner is committed to a county jail in a criminal action, the Board of County Commissioners shall allow the sheriff reasonable charges for maintaining that prisoner. The bill changes the word charges to funding, and then it just makes technical corrections throughout the rest of the statute. Section 7 amends KSA 19-1911, which requires the sheriff to keep and any process and return that is related to the prisoner's custody. This bill modernizes language in that statute, and it adds provisions from the current law in 19-1912 and 19-1913 with that modernized language, and allows for the paper or electronic records similar to those sections. Section 8 amends KSA 19-1916, which authorizes any committing judge of a district court of any county in which there is no sufficient jail to order any person whom they may lawfully order to be committed to prison to be sent to the jail of the county nearest, having sufficient space in their jail. The bill changes that authorization to allow commitment to the jail of the nearest county that has sufficient space and means to care for the inmate as determined by the sheriff or the keeper of the jail in that nearest county. The bill also provides that the sheriff of the county ordering that commitment is responsible for transporting the prisoner in that case. Section 9 amends KSA 1917, which provides that a county jail may be used for the safekeeping of any fugitive from justice from another state or territory, and that the jailer is entitled to reasonable compensation for support and custody of that fugitive. The bill doesn't really change the substantive law here. It just updates the word jailer to reference the sheriff or the keeper of the jail. Section 10 amends KSA 1927, which provides for disposition of real estate in abandoned jails. This bill adds an option to demolish or repurpose that jail or repurpose such site as the Board of County Commissioners of that county deems to be in the best interest of the county. Section 11 amends KSA 1929. That changes the authorization to allow a county to contract with a city in the state or any county in the state that has an adequate jail. The bill also provides that the sheriff of the county ordering commitment is responsible for transportation of that prisoner. Section 12 amends KSA 1930, which requires the sheriff or the keeper of the jail in any county of the state to receive all prisoners committed to the sheriff or jailer's custody by the authority of the United States or by the authority of a city located in that county. The bill provides that the sheriff shall not be required to receive or detain a prisoner who is in custody of an arresting agency until that prisoner has been examined by a medical care facility or healthcare provider if the prisoner appears to be either unconscious or having been unconscious at the time, anytime during custody, suffering from a serious illness, suffering from a serious injury, or seriously impaired by alcohol or drugs or a combination thereof. And the bill goes on to define those new terms. The bill also provides that the cost of that examination and resulting treatment is the financial responsibility of the prisoner receiving the exam or treatment. The Senate Committee on Judiciary did amend the bill here to provide that except as provided in 224612, which is the healthcare provider reimbursement for healthcare services, and 224613, which is the prohibition against releasing prisoners to avoid medical costs. The prisoner shall remain in custody of the arresting agency during that examination required in paragraph 2. And then finally, the bill does outright repeal some sections because of the modernization effort. So you can see those listed there and in the title and the also repealing clause. And I can take any questions.
All right, thank you, Natalie. I have a couple of questions to get started here. Do we define what a healthcare provider is? It says a medical care facility or healthcare provider.
I'm not sure that this bill does provide an actual definition of that anywhere. Are you talking about in the new provision on page 6 related to?
Yeah, when the prisoner has been examined by a medical care facility or healthcare provider. Does that qualify as a paramedic, an EMT, a CNA that happens to be at the jail?
So for that specific provision, you'll see there on page 6 at line 30, the medical care facility, it cross-references 65,425. So we could pull that up and send you a list of what those are. And then the healthcare provider definition goes back to KSA 403401. Don't quote me on this, but I think that's a very expansive definition of healthcare provider. But we could send both of those to the committee so you can see what's all included there.
Okay. Second question, as it relates to this, so it looks like the Senate amended this section 12 specifically to try to address some of the issues around payment. One of the statutes that was referenced, I was talking with Vice Chairman Smith, was 19-4444, which is kind of the further explanation of what happens when a defendant is in custody and the healthcare provider or the hospital can charge their insurance or charge them first, and then if they're unavailable to, then it falls back onto the county. Is that applied anywhere in here? I don't see any cross-references, but I'm concerned overall with the idea that it becomes the sole responsibility of the defendant in custody, and there's no reference back to if that defendant has no ability to pay.
Mr. Chairman, I would have to look into that issue a little bit more. It could be something that Ed might know off the top of his head, being in Chapter 19, if that's another jail provision, that section's not amended in this statute, but obviously all those would be incorporated to the extent that they apply to jails. But I would have to do a little research to see if what is over there is kind of similar to how the process would work here.
Okay, very good. Committee, further questions for Natalie? Representative Schlangensieben and then Titus.
This is somewhat new territory for me, so I think you read a section that had to do with what can happen to a county jail after it's closed.
Yes.
Why is there a state provision for what can happen to a county jail in a bill that has to do with county jails? Am I off base here? Can't the county decide what to do with its own jail? And that's the one question. The other question is, I assume that, let's say a county jail closes for whatever reasons, and so prisoners have to be sent, detainees have to be sent somewhere else for incarceration. I'm assuming the county that no longer has a jail is going to pay for the costs for another county to assume that responsibility, correct?
I would assume so, but we'll have Natalie see if that's specified anywhere in here.
So with respect to your first question, and the language there is in section 10, it's on page 5 if you want to look at it specifically. I can't really tell you why you have a statute that requires the Board of County Commissioners to do certain things with their jail. That's just a policy choice that someone made before. But you can see kind of what those requirements are right there. So right now, with respect to your second question, at least I think maybe what your second question is related to the fact that, so right now, every county is required to have a jail in their county seat. So, I mean, the statute would require that you be operating a jail for those purposes. But, to the extent that a county is going to decide not to have a jail anymore, it does provide that the expense for keeping those prisoners would still be at that county's expense. So they may contract with a county next door to provide those jail services, but they would still be reimbursing for those services.
Thank you, Mr. Chairman.
Representative Titus.
Thank you, Mr. Chairman. I noticed there is a definition of sex or gender in this bill. Were Senate Bill 180 to pass and become law, I noticed that this is an inconsistent definition. Would we be creating a apparent conflict if both bills ultimately pass?
Mr. Chairman, Representative Titus, what's Senate Bill 180? Sorry.
Senate Bill 180 establishing a women's Bill of Rights.
This definition is talking about the definition for this particular statute. The lead-in is as used in this section, so.
But I would say the 180 says notwithstanding any provision of state law. So I believe that would then trump this definition.
Mr. Chairman, I'm not really an expert on Senate Bill 180. I would have to look at that to see whether there would be any crossover there as to the definitions.
Thank you. Additional questions? Representative Resman?
Thank you, Mr. Chairman. Natalie, if one county decides to close their jail, can 2 counties or 3 counties merge into one jail with this bill?
Mr. Chairman, Representative Resman, I want to make sure I understand what you mean by merge. Do you mean like, could they all consolidate to kind of put their efforts toward having one jail in one of those counties and then utilize those services?
Instead of one jail closing and then transporting all the inmates to another jail and then charging back and forth, they just consolidate?
I'm not exactly sure how they envision that work with the contracts between each one of them. As you guys are all familiar, like the Department of Corrections has contracts with some jails and they keep prisoners in some of those jails. So it would probably all just have to be worked out by contract between each of those counties.
But along his same lines, this does allow that the county doesn't have to have a jail anymore, and therefore, based on the other parts of this bill, could take it to the nearest jail or contract with another jail. So I think
yes,
a little different approach to it. Mm-hmm. Further questions, committee? All right, thank you very much, Natalie. All right, we'll now turn to our proponents, Sheriff Easter, Sedgwick County Sheriff on behalf of the Kansas Sheriff's Association. Welcome to committee, sir.
Thank you. Chair and committee members, appreciate you giving me the opportunity to speak today. My name is Jeff Easter with the Sedgwick County Sheriff's Office today. I'm representing the Kansas Sheriff's Association. In reference to this particular bill, Chapter 19, a lot of this was created in 1923, and of course some of the law is antiquated. Some of the questions that you have, that's what we're trying to clear up, is some of the issues with the current statute. When we proposed this bill in the Senate, there was an amendment made to it, which is the amendment that is now the new Section 1 that strikes the word "in custody of a sheriff," and the bill as amended by the Senate committee as a whole. The purpose of this amendment, this has to do with the purpose of this amendment is to assure the provision will include the county jails in Shawnee and Riley County. So we're asking for that amendment to be made in this bill. The reason for that is it speaks specifically to jails that are ran by the sheriff. Both of those counties, the sheriff does not run the jail, the county does. So we're asking for that amendment to be placed into this particular bill. In reference to the amendment that was actually made on the Senate floor, having to do with KDAD's reimbursing the counties for expenses of keeping individuals that are on the waiting list that need to be either evaluated or treated. I have some statistics here that shows that just in the end of January here in 2023, there's 181 males on the waiting list currently that either need treatment or evaluated. There's 8 females. In the month of January, they did 4 mobile services. And the average wait time currently is 430 days for males and 60 days for females. In fiscal year 2022, there was 123 individuals that were treated at Larned or evaluated, and 70 at Osawatomie that were treated. The wait time for Larned for those was 332 days, and Osawatomie was 8 days. And so the amendment that was proposed on the Senate floor, we are in favor of. We didn't ask for that amendment, but it was done by one of the senators, so we are in favor of that. A lot of the other stuff that Natalie talked about, I'm not going to touch on unless you have questions. And so I'll touch on some of the highlights of in this bill. We're asking for the change in language from county nearest having a sufficient jail to nearest county that has sufficient space and means to care for the inmate as determined by the sheriff or keeper of the jail. The reason that we put in keeper of the jail, that includes Shawnee and Riley County. This practical matter avoids the court in another county mandating a prisoner be sent to a different county where the jail is full or does not have the ability to provide the care required for a prisoner. And so this allows the sheriff or the keeper of the jail to determine what is the best place to put a prisoner out of county. And it kind of takes it out of the judge's hands who says, well, you got to take him to, for us, you have to take him to Reno when they might not have the medical services that are needed for this particular inmate. So that is one of the highlights that we wanted to touch on. The most important part of this bill has to do with the current law that requires a sheriff to accept all prisoners, including those that were arrested by other agencies, without any clarity on medical clearance. So we spent all summer last year working with our partners at the Kansas Chiefs of Police Association to come up with what is the best language to use so that it's very clear with individuals that are in their custody that have injuries or are too intoxicated, those type of things, that mandates them to take them to the hospital first before coming to the county jail. And so the proposed language in subsection 2 directs medical clearance is required if the prisoner appears to be unconscious or having been unconscious at any time during the custody or during the events leading to the person's custody. Subsection B, suffering from a serious illness. Subsection C, suffering from a serious injury. Or subsection D, seriously impaired by alcohol, drugs, or combination of. We also worked with the KCP on this particular language, and on the bill itself, starting on page 8, we wrote out definitions to cover what this means. Because that can be, serious injury, how that can be interpreted, those type of things. And so, serious injuries, if we look at page 8, subsection L, Serious injury means an injury with a substantial risk of death or resulting in loss of orientation, loss of full movement of a limb, or a complaint of neck or spinal pain with an onset related to the incident leading to or during the person's custody. A reasonable belief a bone fracture may exist, laceration with appearance that needs sutures, loss or serious impairment of vision with an onset during or subsequent to the events leading to the arrest, loss or fracture of any teeth with an onset during or subsequent to the events leading to the arrest, or any similar condition reasonably indicating immediate assessment by a medical care provider is prudent. Serious illness includes, but is not limited to, any illness or ailment resulting in loss of consciousness or responsiveness or affecting a person's level of consciousness to a degree immediate intervention is prudent. Subsection B, a body temperature in excess of 101 degrees Fahrenheit, acute or chronic blood loss indicative of underlying illness, or pain to a degree that affects the person's ability to function. 3, seriously impaired by alcohol or drugs or combination thereof means the loss of consciousness, inability to stand without assistance, or inability to move from one location to another without assistance, reasonably believed to be induced by the consumption of alcohol or a controlled substance as defined in Chapter 65. And so what was important about that is that it gives really good clarification for the arresting agencies and also for our jail intake people to go by on what it is that when we're talking about serious illness or serious injury and those type of things. And so the next thing that we are asking for, there was some issues that the Kansas Hospital Association had with the way the bill was written when it comes to compensation to the hospitals or the medical care provider on payment. And so we've been working with them for quite some time and also this week and have come up with language that we were told verbally that they did agree with. And so we're asking for the amendment at the current bill right now. Both of these are combined. It's a combined sentence. We're asking for the amendment to separate out these two statements. And so what we're asking to replace the current paragraph with is the following two paragraphs. Subsection 3, except as provided in KSA 224613 and amendments thereto, the prisoner shall remain in the custody of the arresting agency during the examination required under paragraph 2. On subsection 4, the cost of the examination and resulting treatment under paragraph 2 is the financial responsibility of the prisoner receiving the examination or treatment except as provided in KSA 224612 and amendments thereto. So when we look at KSA 224061, what we're talking about there is arresting agencies that come into the hospital and then try to unarrest the individuals because now they have a bill to pay. Under 26 or KSA 224613, they can't do that. And so that splits out that paragraph with the next one, which has to do with the cost. And so what we're asking for there is that the hospitals first try to determine if the patient who's in our custody has insurance, and they bill their applicable insurance first. If they do not have insurance, then they would bill the arresting agency for whatever treatment they got, which is already at the Medicaid rate under 224612. And like I said, those are the things that we worked very hard with the Kansas Hospital Association to make sure we get those right, because we understand their concerns with this, but we also have concerns that we're just billing the arresting agencies or the sheriff's offices without attempting to bill the person's insurance if they have it, because this is taxpayer money that is actually paying for medical costs, and we should not be doing that if they have their own insurance. The Association of Chiefs of Police and the Kansas Sheriff's Association have agreed to work to develop and provide training for the jail staff and law enforcement about these changes. This bill also repeals several statutes that cover things such as language from the alcohol prohibition period, provisions requiring a single religion mandate that is not constitutional, and several statutes combined with other state statutes in the bill. And with that, I will stand for any questions.
Thank you, Sheriff. Committee questions for the sheriff. All right, thank you very much. Not seeing any. You answered my question with the amendment, but I will ask the Hospital Association when they come up a little further clarification. So thank you.
Your question, Mr. Right, yes, if you pass this bill with that change in it, counties could combine into one jail.
Just thinking the profit margin, one county charging another county, or, you know.
Expensive.
Right, and you just kind of cut down on the costs.
Yeah, so this bill, if you pass it, would allow them to be able to combine into a county jail for 3 or 4 counties, as you asked.
Thank you, Sheriff. All right, we're now pleased to hear from Chief Atterbury, Bel Air Police Department, on behalf of Kansas Association of Chiefs of Police, who's joining us on WebEx. Welcome to the committee, Chief.
Thank you for having me, and appreciate the opportunity. Mr. Chairman and committee, as usual, you'll notice that Sheriff Easter has done a wonderful job explaining my positions. He touched on all the high points. I will say that the reason why I agree with him that the section found on page 6 under section 2, number 2, with the outline of what we need to do when we have an unconscious person or somebody who's been unconscious, serious illness, injury, or seriously under the influence of alcohol or drugs. Those are things that have needed clarification for some time because they've been points of contention with city law enforcement and jail staff for many years. We were very happy to have worked with the Sheriff's Association and partner with them and get something that is very understandable for all of our personnel. And we're eager to work with hopefully KLTC, the State Training Academy, to put together training for our personnel so that from the top down, every person in our organizations understands what their obligations are when they have somebody who fits in that section 2 or section 12, part 2. And we are of the firm belief that the operations will go smoother. Those people who need attention for medical conditions are attended to, and they're safer than they have been in the past, that we're going to be able to take care of them as they're in our custody. And with that, I'll stand for questions.
All right, thank you, Chief. Questions for Chief Atterbury? All right, not seeing any. Thank you, sir. Sheriff Easter, I do have one question that kind of popped into my mind that'll specifically apply to you, understanding running the largest jail in the state of Kansas. When we're dealing with fugitive recovery agents, how does this statute apply? Because they are the arresting agency, and what does that look like? And if
I'm sorry. I would say that they fall under this same statute because we have the right then to refuse them coming in. That's part of the problem now is we don't really have the right to do that. So it would be, the same rules would apply to those individuals, whether it's bondsmen, those type of things, and they bring in somebody that fits this criteria, that they need to take them to the hospital.
Okay, that raises further questions on then whose custody they're actually in at that time and who that financial responsibility falls to. Because they're performing their function as ordered by the court to bring them to your custody, and you're saying, yeah, we're not going to take them.
Yeah.
You may not have an answer. It's something we need to think about before
I
we
don't
move
actually
forward.
have an answer for that. That's something probably we need to talk about.
All right, sounds like, well, good questions. There we go. Thank you. We'll discuss that further and think on what we can do about that.
All right, thank you.
Yep, absolutely. Any further questions for the proponents committee? All right, thank you very much. We have written proponent testimony from Jay Hall, Deputy Director, General Counsel for the Kansas Association of Counties. And now we have neutral testimony from Tara Mays, Vice President, State Legislative Relations, Kansas Hospital Association. Welcome, Tara.
Good afternoon, Mr. Chairman, members of the committee. It's not often that I get to appear before the House Corrections and Juvenile Justice Committee. Appreciate the opportunity to be here. I am Tara Mays, and I appear before you on behalf of our 123 community hospitals across the state of Kansas. I just want to express, as we kind of take a look at Senate Bill 228, there are two kind of major components that have an interest, caught the eye of our Kansas hospitals. One of those is certainly don't want to have a lot of unarrested and people being dropped off at the hospitals, particularly during a time when we see really historic patient volumes across the state of Kansas. The other component, which has been touched on here this afternoon, is we don't want to do anything that would contribute to additional uncompensated care in the state of Kansas. We believe that the components that are already a part of the agreement reached back in the early 2000s, back in 2006, that were struck under the current KSA 224612, which was referenced here this afternoon, really does get at a good compromise to make sure that we're not adding to that KSA, to that uncompensated care. And I want to really express our appreciation to the proponents of this bill who have continued to work with us to make sure that we get this language really right, so we're not doing either an injustice to either of those two things. And so with that, we have mutually come up with some language that we think would improve this bill and really clarify both the intention of the proponents and moves us from neutral to absolute proponents of this particular piece of legislation. And that really has been, it is mirror language from what you heard from Sheriff Easter here this afternoon. You can find it on page 2 of our testimony. We just suggest that if you work this bill on page 6, lines 38 through 43, you make a clarification as Sheriff Easter to mention, just to separate those two, just to make it very clear what the intention is. And with that, Mr. Chairman, I'm happy to stand for questions.
Very good. Committee Representative Eric Smith.
Thank you. We referenced that bill earlier, and it comes very timely right now. We have a situation where a hospital is refusing to pay or refusing to bill an inmate's insurance. They say, we will always bill the county. KSA 19-4444 makes it very clear, unequivocal, that we can require that you bill the inmate first if they have the means. So when we book an individual into our jail, one of the things we ask is, do you have health insurance? If they say yes, we ask for their health insurance card. We do that intentionally. Unfortunately, our past precedent so far has been, okay, we'll pay the bill. Now, that doesn't come out of our budget. That comes out of the county general fund. Still, that is taxpayer money that we're using. It also is a little confusing to me. I do have a question at the end of this. It's a little confusing to me that a hospital would refuse to take insurance and instead allow the process of repricing and taking a Medicaid cost instead of actually billing the insurance for. So my question is, does the Kansas Hospital Association support a hospital refusing to take insurance for medical costs? And I'm sorry to put you in that position, but
No, I certainly understand. That's why we don't come before you as an opponent to this particular piece of legislation. What we're saying is we certainly understand and want to do education with our membership to be sure that they're all making sure that they understand the opportunities that exist to them under statute. And so I think having this bill in language clarifies that and really does kind of, I don't think there's any situation where we would want to promote that particular avenue to our hospitals. And certainly what we hear from our hospitals is they get better reimbursement rates from private insurance. So we would hope that they would take advantage of that where we can. And as we can provide education to our membership throughout the state, we would certainly welcome the opportunity to do that. Thank you for the question.
thank you.
Additional questions for Tara? All right, thank you very much. Tara, before you leave, I had CEO of our hospital reach out and share some of her concerns with me, and looking through her concerns, it appears that your amendment and reading through that is going to cover that. So thank you for your work, and we'll work on that.
Absolutely, thank you.
Are there, let's see, we have written opponent testimony by D.C. Heigert, ACLU of Kansas. Is there anyone else wishing to testify on behalf of Senate Bill 228? All right, not seeing any, we'll go ahead and close the hearing on Senate Bill 228, and we will be adjourned for the day. Thank you very much.